Hello, my name's Greg Farrar, and I'm with the Farrar Law Firm and Mediation Group. I'm a practicing lawyer and been doing that for the past 27 years, and I'm also a Supreme Court certified family law mediator. Today we're going to be talking about estate planning and a little bit about wills and estates.
Hi, I'm Carolyn Gramlich. I've been practicing law for close to 5 years. I'm a Supreme Court certified circuit civil mediator, and my family law mediation certification is pending.
I know that most of us just don't seem to really want to think about or talk about estate planning because it's having to deal with the fact that we all inevitably will pass away and we all likely will become sick. And please don't let that be the reason why you don't consider doing the things that would really make everybody's life, including your own, so much simpler and less anxiety and less worry.
And Greg, many people do not plan for their future in terms of estate planning, and we can discuss some of the ways that can be a problem for the family.
Absolutely, and the basic estate planning is planning for your future. And that future, it can be a golden one and a less stressful one if you kind of plan it out, because with some basic estate planning allows you to make sure that whatever your concerns are, whether it's with your children, who will be responsible to care for your kids, or how do you support the kids, and whether they're adults or whether they're still minor children, you can come up with a plan and you can deal with issues regarding your kids and your spouse and your other family members. And this is an opportunity for you to do this in a thoughtful manner and to do it with the advice of an attorney. And we may suggest that you get some tax planning from an accountant or a tax attorney, and you come up with a plan that is best suited for you, that allows you to make decisions and not let the government make those choices for you, which is the alternative when you don't do this type of estate planning.
In Florida, there was a case around the year 2002, 2003. There was a young woman and her husband who did not have any estate planning documents in place, and they ran into a very serious problem that caused years of litigation. Some of you are familiar with the name Terri Schiavo. She did not have a written advance directive stating how she would like to be treated medically in the event of her incapacity, and her parents and her husband, her then husband, again went into a lot of litigation over the matter. What would her intentions have been? She did not express them in writing, so they had to speculate as to what she would want to happen once she became incapacitated. That's just an example of how not having written documents in place reflecting your intentions can be seriously problematic.
And Carolyn, tell the listener, what would be the beginning process and what required information would we typically need, and why is that an important part of the beginning of this process?
An important part of the beginning of this process, we have a will questionnaire that is pretty extensive, and what you would do is you would list your assets, your property, and your intentions for that property. And sometimes it may be considered a tedious task to fill out this questionnaire, but that will help us to develop a strategy for you and to assist you in establishing a last will and testament and other supportive estate planning documents.
And this is so important, whether you were to use this with an attorney or with an estate planner, or just to get your own affairs in order. It's so surprising to me, and let me say that I've been guilty of it myself. We really don't know what we want, and we don't really know what we have. And it's very useful to just sit down and use a document like the one we have available to just kind of get an idea of what you have, and put it on paper. Get a list of the things that your assets, your liabilities, and your loved ones, and plan out how that would be and how it would look like. And so it's really a very helpful document, and it gets you started in moving in the direction of a good plan.
And that's a good point, Greg. A lot of times we're not even clear on what property we have. It's around us, but we don't write it down and think about it and consider how we would like it distributed at the end of our life. So that does help you yourself to plan, just filling out the will questionnaire. In addition to that, when you don't have written documents in place, then upon your death, you would default to the state statutes as to how your property will be distributed. And that's what you want to avoid. You want your intentions to be clearly written and for those things to be carried out upon your death. The 4 essential estate planning documents are a last will and testament, durable power of attorney, living will, sometimes referred to as a medical advance directive, and a healthcare surrogacy. Starting out with the last will and testament. The last will and testament reflects your desires as to how your property will be distributed. Within the last will and testament, you will name somebody as your personal representative, typically with an alternative person should the person you first choose not be able to or willing to serve.
And the last will and testament is one of the just essential estate planning documents. Along with that, durable power of attorney, the living will, and the healthcare surrogate. These documents are what I used to. There was actually 3 at one time, and I used to call them the triumvirate. But it's the basic documents that almost everybody should have, and regardless of the size of your estate, regardless of the of what you believe is the value, and you may think that you have very little or whatever your thoughts are, these documents are just such essential and well-intentioned documents. And the last will and testament, as Carolyn said, is at the time of your passing, it basically describes what you would want to happen to your property and how it would be divided amongst your heirs, and you identify who those might be. And it also gives you the opportunity to describe how you would like your funeral arrangements, what you would like to have done with any of your personal property to maybe a specific friend or somebody that you would want to give some. If you had a buddy that you wanted to give your fishing pole to, you could say it in your will. And there's so many other things that you could do which avoids putting your loved ones in the position of having to make those decisions for you or in your absence. And also it avoids the possibility of having the government tell you how it's going to be done through the intestacy, which are the laws regarding when you die without a will.
The durable power of attorney is probably one of your most important, maybe even a little more important than the last will and testament documents to get into place. In the event of incapacity, if you have a durable power of attorney, it's likely, quite likely, that the court is not going to order a guardianship, a court-ordered guardianship. And a power of attorney gives your agent the ability to act on your behalf, to carry out financial transactions, and to take care of your business. In October of 2011, the law changed, the power of attorney changed pretty significantly, and now you have to enumerate certain powers that you want your agent to hold for you.
And I'll tell you, Carolyn, isn't it such a difficult thing when you deal with this, and you have a long-term married couple that one of them becomes incapacitated, and it happens more often these days because we're living longer, and such things as stroke or Alzheimer's or any number of different things happen that can incapacitate a spouse, and what happens is, although one spouse may have always done legally, and it's not uncommon for spouses to sign the other's name to documents, etc. But once somebody becomes incapacitated and anybody looks at that closely, those documents are not truly legal. And ultimately, if they don't have a power of attorney in place, you have to go through a court-ordered guardianship or conservatorship, which just by its name sounds awful, and it truly is, because it requires people to spend their money that they typically don't have and have to get lawyers and judges involved to make such basic decisions as to whether to sell property or whether to transfer things back and forth. And all that can be avoided with such a simple document, which we call the durable power of attorney.
Yes, and many attorneys will charge a retainer of $5,000 just to begin a guardianship. And as Greg mentioned, it's a tedious process, it's expensive, time-consuming, and it's also very invasive. You have an examining committee that examines the person to determine their incapacity, and then there's ongoing intervention into the family's life after that adjudication. And so the power of attorney can avoid all of that. It's a lot cheaper. Most powers of attorney cost anywhere from $150 to $250, which is a significant savings from a $5,000 retainer for a guardianship.
Absolutely, and it allows you to choose who you would want to have that ability to do legally for you, and it also allows you to do that immediately, and it's something that people use every day. We're in a military community in Pensacola, Florida, and it's not uncommon for a spouse who's in the military to be stationed elsewhere, and a power of attorney to the remaining spouse allows them to do things such as buy or sell property or a car or do a house. All those things can be done, and it's a document that is useful the day you sign it. But the thing I always suggest and remind is make sure that the power of attorney is given to somebody you trust.
Absolutely.
But certainly such an essential part, and I agree with you, Carolyn, that this document oftentimes seems could be such even more important than the will as you do your estate planning, because it does. I see it being impacted so often, and it's something that really everyone should have. And it doesn't really, and you also should have it for your children. It's not uncommon if parents are unavailable that you need somebody like a grandparent or a friend to watch your children and take care of your kids and to make sure that they can get medical treatment. And if you did, there's a specific type of power of attorney for that situation, and we call it a limited power of attorney or a designation for child care. And that type of power of attorney, a very simple document, if in the event that one or both of the parents are unavailable for whatever reason, can allow for somebody to do legally. And that's another, just a part of that power of attorney family. And so consider that document as part of your estate planning. The final documents which we intend to talk to you about today are the living will, which is a medical advance directive, and also a healthcare surrogacy. And these documents, again, are part of that important basic estate planning. And I know, Carolyn, you've had some personal and litigation experience dealing specifically with these documents.
Yes, Greg, I have. I worked for a law firm in South Florida, and most Floridians are familiar with the Terri Schiavo case that I think it was initiated around the year 2003. And by the time our firm got involved in that case, it had already gone to trial. It lost on appeal at least once, maybe twice. And it was a case where Terri Schiavo, a young woman, had some kind of injury, and she did not have a medical advance directive. And the litigation involved toward the end of it was that the parents wanted to take her home and care for her at their own expense, and the husband did not want that to happen. He wanted her to remain in hospice. And so what happened was the decision was made that the husband would be allowed to make that decision in the absence of anything written by Terri Schiavo. And the litigation involved a lot of questioning as to what would Terri Schiavo's intentions have been. And there really was never any clarity about that, but the court made the decision that the husband had the authority. In that case, if she had had an advance directive, it would have been very clear what her intentions were. Would have avoided all that expense, all the litigation, and the heartache that the family had to go through.
And I think it's, again, I've actually seen this document in use, and it's such an important thing because I think we each personally, and whatever, regarding our religious convictions, regarding our personal beliefs and our personal preferences regarding such an important thing as what happens if you become incapacitated and the likelihood of your recovery is not very great, whether you want to be kept alive indefinitely or whether you would want to be allowed to die with dignity. And those are such important life-altering decisions, and oftentimes if you have not made those elections or directives, what happens is that's placed upon the family members or your spouse or other individuals, and that is such a heart-wrenching thing that they have to decide on your behalf that you could avoid with just this simple document, which is very readily available. I know most times when I get admitted to a hospital for any reason, they invariably will have that type of form available, but don't rely upon that because it's such an important document that you may not have the ability to sign it before you go into a hospital, and it would be something that you would be able to do in advance.
And the other document that Greg referred to earlier, other than the living will, also known as a medical advance directive, is the healthcare surrogacy. Essentially, that's a document that provides for somebody to make decisions for you in the event of your incapacity. So you're actually naming somebody to make healthcare decisions for you. Again, it's a very high duty under the law to carry out your wishes and desires. And the living will and the healthcare surrogacy go hand in hand.
And that healthcare surrogacy, you can talk in advance to the individual that you give that right to. And you also, on the document itself, it refers to different types of treatments that you can make a decision whether you want that continued or not. And again, it puts you in the driver's seat, and it puts this, allows you to make those decisions now rather than put that on someone else later. And it's such an important document.
Greg and I are encouraging you to contact us for discussion about your own estate planning. Each family and each individual has unique needs, and what we would like to do is sit down with you and talk about your needs and desires and come up with a strategy, a plan, and an estate planning packet. And with our experience and our understanding of the law in these areas, we can assist you to come up with a plan that is best for you and your family.
And I encourage you to do it soon. When we put things off, we oftentimes never get around to it. And some of those things that we don't address and kind of deal with and make sure that your wishes are going to be followed, it comes back, and so it truly is something that we both feel so strongly about. Is something that saves you so much time, so much money, so much anguish and grief. And so please, just consider, downloading the questionnaire and coming and filling it out, giving you all the information that we need, and then come in and let's talk.
We look forward to meeting you and serving you, and have a wonderful day.
And God bless you.